Okay, so good afternoon, everyone, and welcome to the Ajax Public Library Program, Sexual Harassment in the Workplace, presented by the Durham Community Legal Clinic. My name is Heather, and I am a Community Engagement Associate here at the Ajax Library. I want to begin by just quickly covering a couple of housekeeping items. This afternoon's program is going to be recorded, so I would ask that you please keep your microphone muted and camera turned off so that you're not heard in the recording and to minimize distractions. The chat button is along the bottom of your screen. If you have any questions or comments you would like to share, please feel free to ask questions throughout the presentation. And our presenters, Kelsey and Reed, will either get to them during the presentation or at the end. If you require confidential advice, please send a private chat message to either a library staff member or the two legal advisors, and we will follow up with you. Just as a test for the chat function, if you want to share where you're logging on from and your occupation, we would love to see where you're from and get to know a little bit about you. If you experience any technical difficulties, I recommend that you would exit the Zoom meeting and re-enter. If you continue to have difficulties, please place a comment in the chat and myself or another member will assist you. It is my pleasure now to introduce our speakers today, Reed Jackson and Kelsey Henderson. Reed and Kelsey are community legal workers and paralegals with the Durham Community Legal Clinic and are working on sexual harassment in the workplace project. Reed focuses on human rights law, employment law, and workers' compensation. He was previously a human resources specialist in the construction industry with a focus on labor relations and workplace investigations. Kelsey focuses on Ontario Disability Support, Ontario Works, and Canadian Pension Plan disability disputes. The two of them are part of the Durham Community Legal Clinic that offers free legal services for low-income residents in the Durham region. We are lucky to have them with us today, so without further ado, I will turn it over to Kelsey and Reed to begin the presentation.
Thank you, and good afternoon, everyone. Thanks for coming. So as Heather said, we're from the Durham Community Legal Clinic. And we'll be presenting on sexual harassment in the workplace. So just a quick disclaimer before we get started. All the information that we'll be discussing today is just general information. It is not to be taken as legal advice. We're just going to be giving general information about sexual harassment in the workplace. If there are any specific questions, though, about any circumstances, then you can always give the clinic a call and we'll have our contact details at the end of the presentation. So just to introduce us and what we do, our areas of practice that we focus on are landlord and tenant board. This is tenants only. We also assist with Ontario Works disputes, Ontario Disability Support Program disputes, Canada Pension Plan disability, Workplace Safety and Insurance Board, employment law, and then of course the sexual harassment in the workplace. We also have, it's called the Access to Justice Hub. It's kind of a collaboration between Durham College and our clinic. It is where paralegal placement students work on small claims court files and provincial offenses files. So the services that we provide within these areas of law are, so it ranges from just summary advice to full representation. If it's something that we can't assist with, then what we'll do is try and refer you out to another organization. We also are able to do commissions and notarizations. And then we have a tenant duty counsel program. So you log in if you have a hearing day in front of the landlord and tenant board, and you can access tenant duty counsel, which is just free summary legal advice prior to heading into your hearing. And our services are free and available to everyone who income qualifies within the Durham region. So just a bit about what we'll be discussing today. We're going to start off by talking about the sexual harassment in the workplace project, or the sexual harassment advice, prevention, and education project. We'll be looking at what sexual harassment is, the different types of sexual harassment that can occur, what you can do if you're harassed, and how sexual harassment can be prevented. So just a little bit about the sexual harassment in the workplace project. It exists to address sexual harassment in the workplace. And it is a collaborative project between, I believe, 20 legal clinics within Ontario. It is funded by Justice Canada with the main goal to raise awareness regarding sexual harassment in the workplace. To achieve this, we go and do webinars such as we're doing today. We also can do interactive workshops. We have pamphlets, and then again can give some confidential free legal advice on the subject. Just breaking down the goals a little further. So awareness, we are working to increase public awareness and knowledge around sexual harassment in the workplace. We are also working to provide education. This can be to employees and employers regarding sexual harassment in the workplace. And then again, some advice. So whether it's free legal information or advice to specific individuals about their circumstances relating to sexual harassment in the workplace. And this can kind of range from looking at it from a human rights perspective, and then as well your other employment rights. So just to get us started with what is sexual harassment? So we have just put in the definition here that's underneath the Occupational Health and Safety Act. So it is workplace sexual harassment is engaging in a course of vexatious comment or conduct against a worker in a workplace. And this can be for a number of reasons, so such as sex, sexual orientation, gender identity, or gender expression. And it's where the comment or the conduct is known or ought to reasonably be known to be unwelcome. Or it can also be making a sexual solicitation or advance, where the person that's making the advance is in a position of power, basically over the other person. And again, where the person knows or ought reasonably to know that the solicitation or advance is unwelcome. And then we just have the 3 types of sexual harassment, like 3 broad types. So it can be physical, whether it's like touching or flirting with someone, verbal, making threats or inappropriate humor, and then nonverbal. So, staring at a person or making suggestive noises. And then we've just included more examples of sexual harassment in the workplace that can occur. So again, that can go from, demanding like a physical hugs or invading someone's personal space. And it can also be things that aren't like directly related to sexual harassment about like a specific individual. It can be jokes that other people may find offensive. Or even kind of making someone feel uncomfortable for maybe how they would identify. We've also included employer obligations. So under the Occupational Health and Safety Act, an employer shall, which means that they have to, prepare a policy with respect to workplace violence, workplace harassment. And that policy needs to be reviewed as often as necessary, but at least once a year. These policies also have to be written and posted in the workplace. And in addition to that, the employer should also maintain a program to ensure that the policy is implemented. So the program should involve a system where workplace harassment can be reported, where it can be investigated, and also where others can be provided, the complainant is provided with support. Some more employer obligations. So they also have the health and safety component of it too. After an incident is reported and investigated, the employer has a duty to advise the committee or a health and safety representative of the results of the assessment, and also to provide a copy of that assessment in writing. The employer also has a duty to inform. So they have to provide information, which can include personal information relating to a risk of workplace violence from a person with a history of violent behavior. If the worker can be expected to encounter that person in the course of their work, and if the risk of workplace violence is likely to expose the worker to a physical injury. And then we just written some tips of what you can do if you're sexually harassed. It's really important to write it down and include the exact dates and times, just to kind of amp up your credibility. Review the harassment policy if you have access. Tell someone that you trust. It's a good idea always to get legal advice. So again, you can come and see us at the Durham Legal Clinic. Avoid being alone with the harasser and definitely report it. So whether it's filing a grievance to the union or a formal complaint. And then also, if you feel like it's necessary, contact the authorities and make sure that you get support as well.
And so there are also onuses that are placed upon employers, as Kelsey had previously discussed, when someone reports an incident of sexual harassment in the workplace. And one of the biggest of these components is the duty of employers to investigate complaints of sexual harassment. And the Occupational Health and Safety Act places some pretty stringent requirements for investigations on employers. So essentially, it mandates that they explain how investigations and complaints will be handled, that they detail their measures for reporting incidents of workplace harassment, explain how information regarding a complaint will not be disclosed to anyone unless strictly necessary for the investigation, and set out how the victim and harasser will be informed of the results of the investigation and what steps for corrective action will be taken. So when it comes to workplace investigations, we commonly see employers engaging third-party investigators to conduct them. This is typically done in situations where the complaint is especially complex, or if the employer themselves have failed to investigate a complaint thoroughly, or their own investigation has been extremely flawed. So what does an investigation look like when someone brings forward a complaint of sexual harassment? Now, workplace investigations in Ontario are not necessarily as formalized as some people might believe. Generally, there are a number of prominent law firms, primarily in downtown Toronto, who offer investigations training courses to HR and other legal professionals, but the community isn't necessarily standardized to the same way that you might expect of, for instance, lawyers or human resources professionals. And accordingly, the steps that are taken as a part of the investigation of a complaint are probably going to vary to a greater or lesser degree, depending on the investigator, their background, and where they were trained. But that having been said, there are some standard steps that should always be followed in any situation when one is investigating complaints of workplace sexual harassment. The investigation should always be done in a timely manner. If there's any kind of delay, this can significantly reduce the effectiveness of the investigation. And I think this is obvious why this is. People's memories fade with time. It can be more difficult to get credible statements on the record, and it can be even more difficult to interview witnesses if a lot of time has passed. It's also standard practice to ensure that the investigator is unbiased and properly trained, and of course, properly competent and up-to-date about human rights legislation and the process involved in conducting an investigation itself. Generally, investigations also have to follow those policies and procedures that are set out in the workplace. because failure to follow these procedures properly can have the effect of undermining the entire investigation. Investigators also want to make sure that witnesses are separately interviewed. Allowing witnesses to be interviewed together can lead to cooperation and can lead to testimony that isn't necessarily credible. Investigators also want to make sure that they're telling witnesses that they shouldn't be speaking to one another about the situation at any point before or during the investigation. It's a good idea to make sure that non-leading questions are being asked, because leading questions, of course, can sometimes prompt a desired response rather than an honest one. And finally, it's very important, and this may seem obvious, but it's a stage step that I've seen missed sometimes, but it's very important to always interview third-party witnesses rather than simply the complainant and respondent. Because if it's only the complainant and respondent that you're speaking to, really all the investigator is going to have to go on are issues of credibility, which in many cases end up being more of an art than a science, where if there are third-party witnesses who are available, it can much more easily bring the truth to light in an investigation and doesn't leave one relying only upon assessments of credibility. You also need to make sure that the investigation is properly documented. And further to that, that each step taken in the investigation is thoroughly documented. One of the reasons for this is that if a workplace investigation is conducted and then a lawsuit occurs later on, it's very likely that the investigator's notes and everything that they've produced is going to be subpoenaed and picked over by whatever court or tribunal the investigation and subsequent complaint is being investigated by. It's also incredibly important for investigators to keep an open mind. Many employers, unfortunately, will try to dismiss matters like this, sweep them under the rug, or downplay them, potentially because they don't believe the complainant or because they're concerned about negative publicity arising from the incident. On the other hand, you also have some employers who, the moment a complainant comes forward, automatically assume that the accused is guilty and are ready to move forward with punishment before any kind of investigation is completed. And also, investigators need to make sure that they're considering the entire context of the situation. You need to make sure that you have a full picture of the situation in order to determine the most appropriate response to complaints of sexual harassment in the workplace. As I mentioned before we went over the list of desirable steps in an investigation, we are seeing workplace investigations becoming more commonplace, and it is becoming increasingly common for workplace investigators to receive slightly more formalized training from various law firms or consulting groups. However, I do want to highlight again, this does not mean that investigators themselves are regulated professionals, and there is no formal body which disciplines or investigates workplace investigators. So, if you have experienced sexual harassment in the workplace, what are some of the options that you have in terms of litigation to address that? Well, you can contact the Ministry of Labor if your employer fails to comply with any of their duties under the Occupational Health and Safety Act. And these are things like having a workplace harassment policy and making sure that it's reviewed every year. Having a workplace harassment program that outlines how incidents of workplace harassment are to be reported and how complaints will be investigated and dealt with. And also to provide information and instructions to workers on that harassment policy and its attached procedures. Now, that being said, there are some limitations to what the Ministry of Labor can do, because they're mostly concerned at the end of the day with whether or not the employer has met those obligations under the Occupational Health and Safety Act. So they can conduct an investigation, for instance, to determine if the employer has met these obligations. And if the employer hasn't, then they can issue orders that employer has to comply with the Occupational Health and Safety Act going forward. However, the Ministry of Labor isn't going to be looking into specific allegations to determine whether or not specific incidents of workplace harassment or sexual harassment have occurred. And they're also typically not going to order compensation or any other individual remedies to a particular person who comes forward to them. Now, there are also protections accorded to employees by the Ontario Human Rights Code, which states that every person has a right to equal treatment with respect to employment without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. The Human Rights Code also speaks directly to harassment in employment and states that everyone has the right to be free from harassment in the workplace by the employer themselves, or an agent of the employer, or by another employee on the basis of those same protected grounds that we just mentioned. The Human Rights Code also speaks directly to harassment because of sex in the workplace and tells us that every person who is an employee has the right to freedom from harassment because of sex, sexual orientation, gender identity, gender expression by their employer, an agent, or another employee rather, and also speaks directly to situations of sexual solicitation by a person who is in a position to confer a benefit to that employee. In that you have a right to be free from sexual solicitation or advance that's made by any person in a position to confer, grant, or deny a benefit. And you also have the right to be free from reprisal or a threat of reprisal for the rejection of any sexual solicitation or advance, including from a person who is in a position to confer, grant, or deny a benefit or advancement to the person in question. So we've used the word harassment a lot. What does that mean when we're looking at the Human Rights Code? Well, under Section 10, harassment is defined as meaning engaging in a course of vexatious comment or conduct that is known or ought reasonably to be known to be unwelcome. So what does this mean? That is known or ought reasonably to be known to be unwelcome? Well, this means that it has both an objective and a subjective component. The objective component is whether or not the person who is doing this behavior knew themselves that this action would be received poorly or would be unwelcome. It also has a subjective component. And in order to understand that, we need to think about this in the context of a reasonable person. And we need to look at it and say, how would a reasonable person look at this? And how would they generally feel about the behavior? And if that person would generally feel like that behavior is unwelcome, then it ought reasonably to be known to be unwelcome. So, what is the process if you've experienced sexual harassment in the workplace and you would like to apply to the Human Rights Tribunal of Ontario? Well, it starts with an application or Form 1. And this is where you list your personal contact information, the respondent's contact information, and provide the tribunal with a sense of what happened, including location, dates, and times. You want to be as precise as possible when describing these and try to capture every event. It's crucial that you make sure that the application is filed within 1 year of the harassment occurring. The Form 1 is also used to explain to the tribunal exactly how the events affected you It allows you to tell the tribunal what kind of remedy you're seeking. And the tribunal has the power to grant a number of different types of remedies. They can grant what are called monetary remedies, which can provide you with general damages, which are intended to compensate you for injury to dignity and self-worth. And they can also provide you with what are known as special damages, which are entitled to put you in the position that you would be in had the discrimination not occurred. So, for instance, that could include an award of lost wages, or it could include reimbursement for counseling services that became necessary. The tribunal is also able to order public interest remedies, and that could be something like making your employer create a more robust anti-sexual harassment policy and make sure that it's enforced. Or it could mean that management have to take a number of courses on how to properly investigate and how to curtail sexual harassment in the workplace. The Form 1 is also going to ask you if you're willing to participate in mediation. It's going to ask you to list any important documents you may have and let them know about any possible witnesses you may want them to call if a hearing becomes necessary. Now, once this application is filed with the Human Rights Tribunal, they will serve it to the respondent, who's typically your employer, on your behalf. And the respondent is going to have 35 days to file a response. If they don't, you may be able to push for what is essentially a summary judgment in your favor, where you essentially win by default. Now, that all sounds great, but I'm afraid that expectation and reality are a little bit divorced at the moment when it comes to the Human Rights Tribunal of Ontario. In an ideal world, one would file a human rights application and it would move fairly quickly through the human rights process. And that would mean that after you filed your application and the respondent has filed their response, their version of events, a mediation would be scheduled where everyone would get together on a Zoom call, a mediator would join and would bounce back and forth between the parties, trying to see if a resolution is possible that day. This mediation will be completely confidential, and the main goal, more than anything else, would be to try to find a resolution that would work for both parties. If the mediation is unsuccessful, then your matter would move on to a hearing. What will happen there is that an adjudicator from the Human Rights Tribunal will listen to both sides and both versions of events and will make a decision in writing, which can take up to 6 months to receive, though sometimes much longer, and will send it to both parties and outline any orders and remedies awarded. Now, all of this sounds great, but in reality, the human rights process in Ontario right now is taking much longer than this. In fact, Tribunals Watch has actually issued a statement warning about the inordinate amount of time that some applications are taking to pass through the tribunal process. And in some cases, we are seeing applications take up to or over 8 years from the time that they were filed to actually being resolved. So I want to highlight today that this is a process that, while it can have some very beneficial outcomes, is not necessarily operating in the manner in which it was intended to be at this particular point in time. If you've experienced sexual harassment in the workplace, going to the Ministry of Labor or filing a human rights complaint isn't your only option. You are also able to file what's called a mental stress claim with the Workplace Safety and Insurance Board. But the requirements for doing so are going to be a little bit more onerous than they may be to bring a human rights complaint. Before a claim can even be looked at and decided and adjudicated, you must make sure that you have a diagnosis in accordance with the Diagnostic and Statistical Manual of Manual and Mental Disorders. This diagnosis can be provided by a physician, a nurse practitioner, a psychologist, and/or a psychiatrist. So, in what situation could you be entitled to receive benefits for a mental stress claim? Well, there are some conditions that are going to have to be met. As we mentioned, that mental health professional is going to have to provide a diagnosis first and foremost. You will also have to have experienced a substantial work-related stressor. An example of that could be experiencing sexual harassment in the workplace. This work-related stressor must also be the predominant cause of the diagnosed mental stress injury. And a workplace stressor is generally considered substantial if it is excessive in intensity and duration. For example, harassment. In order to initiate a workplace safety and insurance board claim, the worker can file what's called a workers' report of injury, or Form 6. This can be done via mail, via fax, or online. You can also simply call up a WSIB representative and start the process that way. You're also going to want to speak to a health professional and ask them to complete and submit their report for occupational mental stress, which is Form CMS8. It's also possible for the employer themselves to initiate a workplace safety and insurance claim by completing and submitting their own version of the Form 6, which is the Form 7, or Employer's Report of Injury or Disease. Now, that said, we always like to say it's never a good idea to rely on your employer to start this process, and it's always a good idea to take the initiative and make sure that you're taking appropriate steps to start the process yourself as well. So, once you've done all of that, how does the WSIB determine whether or not you're actually eligible to receive WSIB benefits? Well, in addition to everything else that we've discussed, at a minimum, you're going to need to meet 5 criteria. There's going to need to be an employer, a worker, a personal work-related injury, proof of accident, and compatibility of diagnosis to accident or disablement history. Now, the first 3 of these lists are pretty straightforward and are pretty commonly present. It's number 4 and 5 where WSIB claims tend to have the most difficulty. Proof of accident, for example, could include things like, were there any witnesses to what took place? Did the person report this within a reasonable amount of time? Did they seek medical advice within a reasonable amount of time? And number 5, compatibility of diagnosis to accident and or disablement history, considers whether or not the diagnosis, which has been provided by a medical professional, could reasonably be expected to follow from the personal work-related injury that has occurred. So, with all of that said, what does the Workplace Safety and Insurance Board do if you initiate a claim? Well, they can provide wage replacement benefits. They can provide you with prescription medication, treatment, and psychological assessments, and can provide a return to work specialist who can assist you with creating a return to work plan and a safe return to work process. I want to stress right off the bat, this is a lengthy and often complicated process. It can be very stressful to navigate the WSIB if you are an unrepresented person, and you do require a diagnosis from a medical professional to even begin to start thinking about implementing the process of a mental stress claim related to workplace sexual harassment. What I typically tell persons who visit our clinic about this is that this is the type of claim which is almost always denied at first and almost always requires an appeal through the Workplace Safety and Insurance Board in order to be successful. So let's take a little bit of a closer look at some of the remedies that can be provided by the Workplace Safety and Insurance Board. Well, they can provide you with healthcare benefits, and that essentially means taking care of the cost of any healthcare treatment, including travel to and from, which is received as a result of the harassment. They can also provide loss of earnings benefits, which are essentially wage replacement benefits for any time that you've had to be off work. And these are typically 85% of your net average earnings. Finally, if the workplace harassment has been so severe that it's caused you to suffer a permanent impairment, you can also be provided with what's called a non-economic loss award, which is a lump sum or ongoing payment, which is made to those who have that kind of permanent impairment. So, what does the adjudication process at the WSIB look like? Well, as soon as that Form 6, that Form 7, and the medical information from the healthcare professional is received, the WSIB is going to begin the process and take a look at everything. They're going to look at all the information they have and see if they can determine causation. They'll determine whether or not you're actually entitled to benefits, whether or not you're able to return to the workplace, and whether or not any follow-up is needed. They're going to make a decision, which will be mailed to you and will outline which benefits, if any, you're going to be entitled to in this situation. Now, if you don't agree with the decision that they have made, you do have 2 steps to appeal. The first thing that you're going to want to do is make sure that you've submitted what is called an intent to object form, which must be filed in writing within 30 days for any decision related to return to work, or within 6 months for any other type of decision, including decisions about your entitlements to WSIB benefits. It's possible at this stage for the WSIB to change their decision and to award you benefits. However, if they elect not to change their initial decision, they will send you back a copy of what is called your claim file. And that is basically every piece of information that has been created as a result of this workplace injury or workplace harassment. So doctor's reports, any notes, the transcripts of conversations that you've had with persons at the WSIB, memos that have been written internally at the WSIB, everything that's been produced related to your claim. They're also going to attach what's called an appeal readiness form to this. And this appeal readiness form allows you to request a hearing in order to have your matter looked at by another person within the WSIB called an appeal resolution officer who hasn't been involved in your process thus far to determine whether or not you have entitlements to the benefit that you're seeking. Now, these hearings generally take place either orally, via writing, or as a teleconference. Currently, most oral hearings are taking place over Zoom and other telecommunications software as a result of the ongoing pandemic, and written hearings are proceeding as normal. Hearings are going to be heard by an appeals resolution officer, and their decision will be final as far as the WSIB is concerned. However, if you do not agree with the decision at that juncture, you do still have another avenue open to you. You are able to appeal to the Workplace Safety and Insurance Tribunal, which is an independent tribunal within Ontario, whose mandate is to review the decisions that have been made internally at the Workplace Safety and Insurance Board. So, how can we prevent sexual harassment in the workplace? Because as much as it's nice to know about the ways that we can go about seeking recompense when such an act has taken place, what is really ideal is the elimination of sexual harassment from the workplace entirely. It starts with cultural competence, which is the ability to understand, appreciate, and interact with persons from cultures or belief systems different from one's own. It's also crucial that we all understand the definition of sexual harassment. It can be useful to host training sessions annually and as part of the new employee orientation process to make sure that everyone in an organization is on the same page about sexual harassment. It can also be useful to try to foster the kind of culture that creates safe, judgment-free spaces. And it's extremely important to recognize that when it comes to sexual harassment in the workplace, There isn't necessarily a one-size-fits-all solution. And what works in one workplace or one industry may not work in another, depending on what the culture of that workplace is or what the history of that workplace is. And it's incredibly important that we remain open-minded to creative solutions as we look for ways to curtail workplace sexual harassment in the future. So, to wrap things up, if you have experienced sexual harassment in the workplace, you are not alone. You need to get support from someone that you trust. Report the incident as soon as you feel comfortable doing so. And if you see someone being sexually harassed, be supportive and ask them what you can do to help. Don't assume, ask. And finally, you can get legal advice to determine the kinds of remedies you can seek, what your rights are, and what you can do in order to try to prevent sexual harassment at your workplace going forward. And as part of that, you're always welcome to come and see us here at the Durham Community Legal Clinic. We hope that you found this presentation helpful, and if you have any questions, we would be happy to take them now.